I'm here today to talk about how our ancestors experienced the U.S. Southern Claims Commission experience. I feel that it's so common for us as genealogists to find an ancestor mentioned in a document, take what we need for our genealogy, and never think about what our ancestors experienced at that time, which can add so much to our picture of that ancestor. In the case of the U.S. Southern Claims Commission process, even if your ancestor never participated in it as a claimant, witness, or official, reading through the claims for the county you're interested in can add so much to your understanding of your ancestor's life, and it's the little details that make the difference. I'm going to explain how the Claims Commission, what the Claims Commission was, how it worked, who it affected, and how the process of imagining what it was like for the participants can change your perception of what the documents say. My research is primarily in Liberty County, Georgia, so I'm going to use examples from there. I have a digital genealogy project called theyhadnames.net that focuses on documenting the names of African Americans in early Liberty County records. We've so far transcribed over 60 of the SCC claims from Liberty County, and the process of focusing on the community experience has really changed how I see those records. First, what was the Southern Claims Commission? After the Civil War, the U.S. government began to consider what it owed Southerners who had had property confiscated by the U.S. Army. The Southern Claims Commission was created by an act of Congress on March 3, 1871, to determine whether the applicant had been loyal to the Union, which was a requirement for compensation, and how much should be awarded in compensation, which meant valuing the property that was lost. Claims were either allowed, disallowed, or barred. Barred meaning the applicant was not eligible for the program in the first place, usually because they had been discovered to have supplied stores or material support to the Confederate Army. Overall, there were 22,298 claims and only 32% were approved. As the name suggests, the program was only for the southern states. Only residents of the 12 southern states could file a claim. But if an individual had moved to another state or even another county, but had incurred the losses in an approved state, they could also file claims. So the records include claims from a total of 24 states. So where do we find these case files? The original records are held at the National Archives and Records Administration. They've been digitized and are also available on Ancestry.com and Fold3. As well, the Family Search Wiki has a great deal of information about how to use the files and other information you'll need. And the St. Louis County Library has an excellent section containing copies of, for example, the questions that were used and all kinds of other information about working through the process of finding the claim for your ancestor. I have some bad news about them being online. Some of the case files online are very faded. Our plan for my website was to transcribe all of them, but some were so faded as to be illegible. However, when I reached out to a professor who had done some research on them, when she gave me her notes, which she had made while looking at the originals at NARA, I discovered that she had notes on things that I couldn't read online. And I've gotten pretty good at reading the files, so they were truly illegible online. She confirmed that the digitized copies online are not as legible as some of the ones at NARA. I don't say that to discourage anyone from using the online files, but if you find something that's important for your research that isn't legible, NARA may be the only way to go. I have had good success, though, with downloading the pages and playing with the light-dark contrast to make them more legible, as in this one, which has gone from, I might not be able to get a few of the words to probably can get all of it. Some of them, I'm afraid, though, are just truly illegible. The first thing to do is to read about and understand the process. As I mentioned, the St. Louis County Library has an excellent set of web pages about this. And again, the Family Search Wiki, definitely you'll want to check out. The St. Louis County Library website has the standard questions that were asked of every claimant and witness. The set of questions changed, I believe it was 3 times. at different times during the period when the program was active, and they're often not included in the file. So if you don't have the list of questions, you can't know, say, if it says the answer to number 7 was no, well, what was the question? So they have this list, and it's very important to find the right list for the year for the claim that you're looking at. They The questions we just saw were from a set used to prove the claimant's loyalty to the union, without which the claim would be denied. The second set of questions was about how the items claimed were taken, and it describes them and attempts to put a value on them. The case files, which can be found online at Ancestry in Fold 3, are indexed by both claimants and the witnesses, and they generally include all the papers that were in the original file, including the original application, any amended application, testimony by the claimant and his or her witnesses, a list of the property taken and its values, the commission's verdict, a special agent report if any, and if the claim was successful, the paperwork for generating the award money, which will tell you who the money was given to. The process could take years, and if the verdict was appealed, it could take decades. Let's walk through what it looks like to search for one of these records on Ancestry. You go to search and then search the card catalog. Now, however you might be used to doing this. As you search the card catalog, type in Southern Claim Commission as the title, and it will give you 3 files. The master index, the allowed claims, so the disallowed and barred will go to the allowed claims. And then we're going to put in the location. I'll put in Liberty County. You could put in Rockdale County, Newton County, whatever you happen to be looking for. It will pull up a list of people with allowed claims. And then you can click on photo or view record to see the claim. It will show you first a cover page that has the claim number, which you'll want to notice. Then as you page through, it will show you parts of the application. This includes the items that were taken, more of the application process, again, the application process. Again, application of testimony taken, and then you get to the point where the actual testimony, here are the witnesses that are being called, and then this is the first part of the testimony, and then this is where we get into the actual testimony of the claimant and the witnesses. Since my research is for Liberty County, let me set the stage for Liberty County, since I'm going to use the process that happened there to illustrate why you should care about the process when doing your own research into the Southern Claims process. When Sherman's army reached Savannah in 1864, following their march from Atlanta, which I believe went through your area as well, they were hungry and tired, and their horses and other stock animals were giving out. So the army turned back to Liberty County, just to the southwest of Savannah, which was a wealthy farming community where most of the white planter and slaveholders had fled. You can see a present-day map showing the location of Liberty County in relation to Savannah. The white families had refugeed some of the enslaved people to other locations, but others remained on the mostly deserted plantations right in the path of the army. The Southern Claims Commission testimonies paint vivid pictures of the encounters between the foraging soldiers and the population that was left in Liberty County. Liberty County had a relatively high claim rate compared to other southern counties, I'll explain why later, and an even higher approval rate. Most of the petitioners were African American, and they had formerly enslaved, and they had a higher rate of success, mostly because the white petitioners had a great deal of difficulty proving their loyalty to the Union. After all, even if a white resident had such sympathies during the Civil War, it wasn't really wise or safe to express them, so it was difficult to prove afterwards. The Southern Claims Commission was troubled by how many claims came out of Liberty County. As we'll discuss later, many of the claims appeared to them suspiciously similar, and they thought exaggerated. We'll discuss why that was, how much might have been true, and how much can be attributed to the racism of the parties involved, which we'll discuss in a minute. I mentioned that I have a website called They Had Names, where I post abstracts and transcripts of documents naming African Americans in early Liberty County records, and that the site has so far posted 60 full transcripts, more than 60 full transcripts of the Southern Claims Commission case files, and I've posted research on more than 40 of the claimants, tracing their lives backward earlier than the Civil War and forward. Kathy Dillon, a wonderful person who has done many transcripts for the site as a volunteer, transcribed many of the claims. Reading all the claims and researching them is how my view of the process came to change. I originally took everything at face value. It wasn't until I began to think about how the process actually played out for everyone that I realized how much human interactions, animosities left over from the war, and good old human frailties affected the outcomes. Some of you may be wondering why enslaved people had property to take. The property taken by the soldiers from the enslaved people consisted mostly of cows and hogs, rice, corn, and potatoes, sometimes honey, and occasionally a horse and a buggy. In Liberty County, most slave owners used the task system, in which an enslaved field hand would be assigned a certain amount of work, and if he or she finished the work before the end of the day, the rest of the day could be used to raise stock, plant crops on unused land, etc. Often the arrangement was that the enslaved person would sell the produce or meat to the slave owner or on the market. This practice had multiple advantages for the slave owner, including tying the enslaved person to the land to discourage running away. For a more detailed discussion of the complicated background to this process in Liberty County, I've linked in the handout to excellent articles on the subject. The task system is why there were many more formerly enslaved people filing claims in Liberty County than in other counties, because they had property that could be and was taken. As you can imagine, given the time and the place, the claims commissioners struggled in particular throughout the program with whether or not slaves could be considered to have owned property. In a convoluted piece of logic, they sometimes reasoned, and they weren't always consistent, that any property, especially food that was owned by an enslaved person, would have had to be supplied by the slave owner anyway, and thus not only was really the property of the slave owner, but actually aided the Confederate effort. One of the lawyers had a dry and successful response. He said, to say that this property belonged to the master and therefore it should not be paid for does not look very well from the high moral anti-slavery standpoint. He did win that case. The commission came to accept that enslaved people in Liberty County had owned property, and that in fact this property was often used to supplement what was provided and as luxuries. Drivers were enslaved people who were assigned a supervisor position on the plantation. They had particular opportunities to obtain property and were overrepresented in the Southern Claims Commission petitions compared to others. The Southern Claims Commissioners originally misunderstood these opportunities and concluded that a supervisor who did not work the fields himself would not have had a chance to own property. However, it was just the opposite. There were many testimonies that the drivers were able to have other enslaved people tend to their property and that they received special privileges. Enslaved people in Liberty County considered themselves freed once the U.S. soldiers showed up and told them they were free. The Army stripped the county of everything there was to eat and any animal who could provide transportation, leaving the remaining white planter families in a state of helpless rage and fear. The now freed people, as you can imagine, had a different reaction. After the first shock and fear, many of the African American claimants described going to the soldiers' camp to cook or do laundry for them. It was December, and John Bacon, a formerly enslaved man, testified that it was cold and that the soldiers needed things like blankets and quilts. Many of the African American claimants said they freely gave the hungry soldiers what little food they had. When Kathy and I started transcribing the case files for Liberty County, I really just paid attention to the testimony, and I took it and the comments by the commissioners at face value. The more we did, though, and the more I researched the claimants, the more I saw the overall process and realized how easy it would be to misinterpret something if I only read one claim because, for example, my ancestor was in it. As we all know, of course, the post-war period was a complicated one, and many societal forces were combining in this one seemingly simple application process. There was a deep racism permeating all aspects of the process, as we'll discover, and also a more subtle sense of class. Although well-off white claimants were likely to be denied because of a presumption that they had been Confederate supporters, their testimony was sought after by the special agents who were investigating claims, and often a claim would be denied simply because a prominent white man commented disparagingly about his idea of the character of a formerly enslaved or lower class white claimant. We'll discuss later how the commissioners came to their decisions on the cases, but it's important to remember that this process took place over time and their views changed over time and also were not consistent over time. So just because you read one claim and hear one verdict for one of your ancestors, it doesn't necessarily mean that that was the thinking of the commissioners for the entire time. Let's start with the lawyers and looking at the details. It appears to me, though I can't be sure, that one of the reasons Liberty County had such a high number of claimants was the first lawyer we're going to discuss, James M. Sims of Savannah. Reverend James M. Sims of Savannah was probably the first lawyer to have contact with the Liberty County freed people to help them apply for the Southern Claims Commission program. On September 14, 1872, he brought together the first African-American applicants to write their applications, which required them to declare their loyalty to the United States, enumerate the process they had lost, the property they had lost to the U.S. soldiers, and declare the names of their witnesses, both as to loyalty and as to ownership of the property. The loyalty part was mostly just a formality. The commission assumed that formerly enslaved people had wanted the Union to succeed. Remember, Reverend Sims was able to read and write, as this biography shows. Almost all of the Liberty County African-American claimants were illiterate. This would become a point of dispute because many of the applications he wrote down were believed to have exaggerated the amounts and values of confiscated property. At least one claimant later denied signing the initial application, and others made it clear in their testimony that what Reverend Sims wrote down for them was not what they had originally told him, and usually they had told him less than was written down. There's no doubt in my mind that he believed he was helping them. I can't see what other motive he could have had, but it did end up hurting some of the claimants whose claims were denied. However, it does appear to me that many of the successful claimants owe the fact that they made claims at all to James Sims. I'm the descendant of Liberty County slave owners. That was my primary motivation for starting the They Had Names website. My second great-grandfather, Joseph Ashmore, was the Liberty County probate judge from 1876 to 1889, and lots of Ashmores in the court system after that. So I'm used to seeing my maiden name on Liberty County court records, but I was not expecting to see it in the Southern Claims Commission records. When James Sims brought together those claimants on September 14, 1872, they must have used the same pen for everything, and it was a pretty bad pen, and so those records are very faded, much more so than some of the other documents in the case files, which were written at different times. So it took a while before I noticed that, in fact, where it says witnesses here, that is Joseph Ashmore and his nephew, John S. Ashmore. So they were the witnesses for all the applications that day, which means they were there for the whole thing and saw it. I mean, I would love to find some record of that, but I haven't and probably won't. This is their signatures on Titus Alvin's application. This is one of the good copies, actually, and the one where I finally realized what those names were. The next lawyer was Raymond K. Jr., son of Raymond K. Sr. a land and slave owner of Liberty County, and he was one of the lawyers most frequently seen in these cases. He took on a number of the Southern claims petitions by freed people, but eventually was barred from receiving awards on their behalf by the Claims Commission, which in 1877 called his abuse of his clients the most flagrant case they had seen. He protested that his terms to his client, under which he took half the award, plus double the special commissioner's fee and other fees, leaving his destitute clients with little of the original award money. He said it was fair because he was the only white lawyer who would take these cases from African-American clients. He said that James Sims and W.H. Sykes, both African-American lawyers from Savannah, would not advance their own money to pay the fees. And he left out, of course, the fact he was in a slightly different financial position than they were. The Treasury Department rejected his explanations and assigned the task of delivering the awards to James Atkins, the Savannah Port Customs collector who traveled to Liberty County and did it in person. Another important factor, which I wouldn't have thought about before taking on the project to do so many of the Southern Claims Commission files, is that it mattered who the special commissioner overseeing the case was. The special commissioners, there was one at a time, were appointed by the commission to take testimony in cases where the claimants couldn't travel to Washington to be heard through the commission itself, as was the case for most of the desperately poor Liberty County claimants. For these Liberty County claims, the change in special commissioners over time was highly significant. As I mentioned, there was only one at a time. The first one was Virgil Hillier. He moved from the north to Camden County, Georgia after the Civil War and was elected to the Georgia State Legislature, but lost his seat in 1871. Why does his history matter for these Liberty County claims? Because when he took the testimony of these formerly enslaved claimants, they were speaking to a Northerner who, even though he probably had all the prejudices of his time, they probably presumed was more sympathetic to them. And how can I assume that he might have been sympathetic beyond the obvious fact that he was a Northerner? When I was reading the testimonies taken by him, I wondered whether he actually wrote them down himself, because they're vivid, detailed, and appear to be in the claimant's own words. But I started noticing that an E.E. Adlington was acting as a witness, which is a surname I don't recognize from Liberty County. It turned out that E.E. Adlington was Ellen Adlington, a school teacher from Massachusetts who came to teach in the freedmen's schools. I think it was she who took down the testimonies, and that between the two of them, the freedmen felt more comfortable in speaking their truths. This is where the testimony critical of the slave owners comes from. You rarely see it in the later claims, though even then, the claimants normally say that it was other slave owners, not their own, who were harsh. Remember that no matter who was taking the testimony down, the lawyer in the room for most of these was Raymond K. Jr., who was son of a well-connected Liberty County slave owner who would most likely repeat what was said to others. Hillier was also not free from criticism when the commission accused Raymond K. Jr. of charging double the special commissioner's fee, and noted that if this was true, the special commissioner was also unreasonably enriching himself by taking a fee. Well, it was Hillier they were talking about who was taking the fee. Henry Way, the next special commissioner, was a very different person. For one thing, he was a Liberty County native and a former slave owner. He had extensive family connections within Liberty County, and he was clerk of the Liberty County Superior Court when named special commissioner. In fact, that appears to be the reason he was named the special commissioner, as his successor also held that position. We can imagine that it was a very different matter as a formerly enslaved person, or even a white person claiming loyalty to the Union, to testify in front of Henry Way. In fact, one of the early claimants, while Virgil Hillier had been a special commissioner, had been held in slavery by Henry Way. Prince Stevens testified in 1873 that he had had nothing to do with Way since December 1864. He added that Way had 5 or 6 enslaved people who were 2 families, which is very useful for genealogists. The image on this slide shows Prince Stephen's being used as collateral on a promissory note by Henry Way to Joseph R. Bacon. Is it likely that formerly enslaved people would speak freely in front of Henry Way? There was actually a third special commissioner for a brief period, J. Sloman Ashmore. He was, as I said, also the clerk of the Liberty County Superior Court, which helped me understand that that was one of the criteria for choosing the special commissioners. He was a former Confederate soldier, having been chaplain of the Georgia 25th Infantry Regiment at the end of the war. He was also my second great-grandfather, Joseph Ashmore's eldest son, and he inherited the probate, inherited in quotes, the probate court judge position from him later on. Again, he was probably not an easy person for formerly enslaved claimants and witnesses to testify in front of. Here's the dramatic difference it makes who took the testimony. The testimony taken by Virgil Hillier sounded like natural speech, and it was descriptive. You almost felt like you were there at the scene. The testimony taken by Henry Way sounded robotic and clearly was just notes taken down by someone, probably Robert Q. Castles, who had a store at the railway stop and acted as the claimant's counsel under Henry Way. So imagine that scene in front of former slave owner Henry Way, he's a judge, and white merchant Robert Q. Castles, from whom you have to buy things on credit, and whoever else might be shopping in the store. You would imagine that it would change your testimony. If your ancestor was a claimant or a witness with testimony taken by Virgil Hillier, you were lucky as a genealogist. You would really get a feel for how they spoke, details about their lives, even their emotions about the Civil War. If you only saw the testimony taken by Henry Way or J. Sloman Ashmore, you would have had an entirely different experience, just as the claimants and the witnesses probably had a different experience. It is likely not only that there was a difference in what the note taker chose to write down, depending on which special commissioner it was, but also what the claimants and witnesses chose to say. Something to keep in mind as you're reading through the files. The Southern Claims Commission noticed the difference and made frequent complaints about the lack of detail in the testimony taken by Henry Way. They were obviously suspicious of Robert Q. Castles, whom they described as an attorney, but who probably was not. After reading all the claims that Way and Castles did, I'm also suspicious that some of them might have been made up. I think the claimants are real, but that the testimony may have been invented. There were two special agents seen so far in the process for Liberty County and probably other places, R.B. Avery and W.W. Payne. They lived outside the area and they would be sent in when, as often happened, the commission had doubts about a case and needed more information before making a decision. The special agent report for each case is included in the case file. The reports reveal what was a very obvious bias on the part of the commission for white witnesses who were prominent members of the community, although they did consult certain African-American members of the community whose testimony was kept private. Claims in which only formerly enslaved people were witnesses, and especially if their testimony was taken by Henry Way and R.Q. Castles so that there was little detail, were likely to be rejected out of hand. If there seemed to be some doubt, the special agent would be sent. He would interview Liberty County residents as to the character of the claimant and whether they knew if he or she had owned property before the war. And if he could, he would visit their homes, the claimants' homes. The special agent's reports make for fascinating reading, but the bias is very evident, and it's something to keep in mind if there happens to be special agent testimony in the file that you're reading. The commission constantly struggled with how to value the property that was confiscated from formerly enslaved claimants. It was considered that the property owned by enslaved people was inferior in quality to that owned by whites, particularly when it came to horses and buggies. Finally, the special agent came up with a list that was used in making the monetary awards, though of course it bore no relationship to the property actually owned by any one individual. When George Powell, a formerly enslaved man, submitted his claim in 1878, the special commissioner was Henry Way, the former Liberty County slave owner, who took very sparse and suspiciously similar sounding testimony from the claimants. A number of the claims processed by him were denied by the commission on the grounds that the claimants provided no details about anything. Powell's claim was no different. He provided no details at all. So why was his claim approved when others were not? In this case, his white former slave owner testified for him. In other such cases, the former slave owner was either dead or had left the county, and those claims were mostly denied. So more than a decade after the Civil War ended, Powell still needed the testimony of his former slave owner, a man who might be hostile, dead, or absent, to win his case, even though it had been well documented that enslaved people in Liberty County had owned property and that this property was taken by the U.S. soldiers for Army use during the raid on Liberty County. Powell received $86 of his $220 claim. The Southern Claims Commission was much more likely also to approve a claim if the formerly enslaved claimant had at least one white witness, preferably a former slave owner who would say he knew that the claimant had owned property. The lawyers were evidently aware of this, and they enlisted the services of several young white witnesses, the children of slave owners, who would swear that they knew that the claimant had owned property. Sometimes the commission would accept this, and sometimes they would point out that the witness would have been a child during the Civil War. The special agent would make it a point to seek out prominent white members of the community on his visits to Liberty County to research cases, and he put a lot of weight on their word, both as to the character of the claimant, meaning whether he was an industrious, in quotes, person likely to have owned property, and to the value of the property. It was very common for even an approved claim to have the amount significantly downgraded because a white witness cast doubt on the value of enslaved people's property. So common reasons for denying a claim. The testimony was so weak. And again, that goes back to, was it Virgil Hillier who took the testimony, or was it Henry Way? The belief, the common belief that property of enslaved people must have been such poor property that the soldiers actually stole it for their own use, not for the armies. And oddly enough, if it got stolen for the soldiers' own use, it was a denied claim because they were only compensating for property that had been taken by the army. Or there were no white witnesses in the case of formerly enslaved claimants. The age of the claimant, there were a number of people who put in claims who in the late 1870s were in their 20s. And so the commission pointed out that they would have been very young during the Civil War. The ownership of the property not proven. This often went back to the testimony not being taken well. And then some useful questions to ask yourself when reading a claim, because we've covered the ways in which the process and the participants in the process are important to research as you're looking for your own relative's part in this process. So you might want to ask yourself, where was the claimant living? For example, often they would be living in a certain place when they put in the application, but they would say that they had been living somewhere else when the incident actually happened. So that tells you a lot about what happened to them right after the Civil War. If it's a formerly enslaved claimant, is the surname of the claimant the same as the surname of the slave owner? If it's not, that gives you a clue that you need to go back and look for other possible. Often in Liberty County, if it was a different surname, that's pointing back to an early slave owner of the family. Who were the witnesses as to the signing of the in the initial application, the person would say they were going to call such and such witnesses. And then it might be a few years later that the actual testimony was taken. So did the same people testify? Often it's not. And if you're looking for one of those people who was named as a witness in the initial application, perhaps that's a clue that the person died in the meantime, though it could just be they weren't available or they had a falling out or something like that. Did a witness testify in more than one claim? So if you find a claim and there's the person you're interested in is a witness, go back and look. They might have testified in other claims. That was very common. Again, who was the special commissioner and who was the lawyer? You might want to research them to see if they had any impact on the testimony that was taken. And are people mentioned other than the claimant and the witnesses? Just because the person that you're looking for didn't make a claim and didn't act as a witness, they do mention other people. Because the claims process was only for people who could prove that they had been loyal to the Union, the claims surface stories that are not often told. One of them was that of Elizabeth Summersall and her two sons, John and James. They were poor. They owned a few acres of land. They grew their own food, milked their own cows, didn't own people. They are distant relatives of mine, but I haven't figured out exactly how. When the Civil War started to loom on the horizon, Elizabeth, who was a widow, started telling the neighbors that they shouldn't fight to keep their slaves. She didn't have any, and she didn't want to see the area go to war. John had to tell her to stop, or she was going to get him killed defending her. She did stop. When the war actually started, John knew he was going to be expected to sign up to fight. He didn't want to. How do we know that? From his mother's Southern Claims Commission petition. She called on 3 formerly enslaved men, Sam Elliott, Moke Todd, and Lafayette Delagal, to testify for her. Sam Elliott walked 15 miles each way to testify for her in August at a time when he should have been weeding his crop. He said he did it out of kindness. Lafayette Delagal testified, if I should go to her house now, she would set me at her table just the same as herself. In fact, she used to have a little store in her house. She would sell things to the enslaved people on Sundays. Sam testified that John, her son, came to him on the plantation where he lived at the beginning of the Civil War and asked him to take a hatchet and cut off some of his fingers so he wouldn't have to fight. Sam wouldn't do it. So John and James were forced to sign up at the end of October 1864 as Sherman's army approached Savannah. James was sick in a Savannah hospital. They both deserted, went home to Liberty County to hide in the woods, where one of his mother's witnesses said he used to bring them food. Elizabeth wanted him to hide James, who was still so ill, but he wouldn't do it because he said he had known some slaves who were, quote, whipped nearly to death for harboring a deserter, and that was as bad as shooting would not hurt so bad, unquote. Lafayette, another formerly enslaved man, testified they were poor men. They owned nothing but horses and cows and such things. They could not even go in a rich man's home in Liberty County. John and James died not long after the war. Elizabeth lived to be 84. When she died, she gave her house and the surrounding lot to a much younger sea captain who lived with her, which sounds like an interesting story. And she gave a 10-acre plot of land to a 62-year-old African-American widow, Matilda McIntosh, a formerly enslaved woman who had cared for her. Although there was little testimony in the Liberty County records about personal interactions between formerly enslaved people and the soldiers, the testimonies were very clear that they were overjoyed to see them once the soldiers told them they were free. While disappointed at the loss of their property, Jack Walker said he cried like a child when he saw all his things taken, and he personally complained to the colonel in charge. John Bacon's reaction was more usual. I had rather have my freedom than any horse. Glory to God. At the end of the Civil War, Prince Stevens was an enslaved man in his 30s who couldn't read or write. By the time he died in 1908, he owned more than 500 acres of land. What else happened in the post-war lives of these claimants? Jack Wilson's story is one that illustrates the usefulness of the Southern Claims Commission files for genealogical research. He testified in 1873 that he had been held in slavery on George W. Waltauer's Westfield plantation. He also said that he was currently living on and renting property belonging to John L. Hardin, who was a member of the White LeConte family. In the 1870 census, he is seen living with his wife, Dinah, and working as a farm laborer. However, by 1875, he had bought land from Joseph Ashmore, my second great-grandfather, another unexpected connection for me. By 1910, Jack and Dinah, or Diana, have been married for 48 years and have had 11 children, 9 still living. And one day, while looking through the First African Baptist Church in Riceboro Cemetery, I found his headstone. It's the only headstone I've found so far for a Southern Claims Commission claimant. He had a Mason symbol on the headstone. Unfortunately, his son Jack died in 1929 of a gunshot wound, but his death certificate told me that Jack's wife's Dinah's maiden name was LeCount. So she was likely enslaved by the LeCountes, and this was the reason they were renting the land from John L. Hardin. Aberdeen LeCount filed a Southern Claims Commission petition naming his last enslaver as William LeCount. Aberdeen showed up in William LeCount's 1841 estate inventory. In these estate inventories, I have often found people listed in what appear to be family order. Here you can see that Prince, valued at $500, and Suki, valued at $400, could very well be the parents of Charity, Aberdeen, Katie, and Bristol, who are listed in descending order of values that probably indicates age. I'm sorry to put it that way. While Hamlet, valued at $500, appears to start a new family group. William LeCount's father, Louis LeCount, had an 1838 estate inventory that also shows these individuals in the same order, with Bristol likely born between 1838 and 1841. In the 1870 census, we see Prime and Suki LeCount living in the same household and presumably man and wife. Of course, that wasn't specified in the 1870 census. The Southern Claims Commission testimonies always name the former slave owner, which is a godsend to someone trying to break through what's called the 1870 brick wall, where in 1870, of course, it's the first time formerly enslaved people are named in a census with their surnames. Before that, you're just looking for first names. So how do you connect up the two and find out who the former slave owner was? Having a list of all the claimants and witnesses with their former slave owner's name would be so extremely helpful, but it's a mammoth task. Fortunately, for everyone interested in this history, Dr. Peggy Hargis, retired associate professor from Georgia Southern University, had already compiled this list for Liberty County. And the Dorchester Academy African American Museum in Liberty County had it in a remarkable exhibit that she created. The museum is definitely worth a visit. It not only has this exhibit about life before the Civil War, but also a newly created permanent exhibit about Liberty County's remarkable relationship with the Civil Rights Movement. So I took this list and I made a sortable spreadsheet out of it so that people can sort by the slave owner name and find all the people that were owned by them. One side benefit of the list is that we now know that of the 275 people named in the list, only about 10% took the surname of their last enslaver. From my research, I believe that those who did so either likely had a biological claim to that last name, or their families had been enslaved by that family for a very long time. In researching why freed people took particular surnames, I have often found that surname far back in the family's history as an early enslaver of an ancestor. I'd love to be contacted by anyone who is interested in Liberty County records. I try to make sure that as we process records, I put them online right away, but I've learned a lot about how to research in Liberty County, and I'm happy to share that knowledge with anyone who's interested. I know you all are probably interested in the other counties. As you go through looking for Southern Claims Commission files, if I can help in any way, please don't hesitate to contact me, and I would be happy to take any questions at this point.